Good afternoon, good Saturday afternoon, everybody. This is Mark Wallace, your host and facilitator here with you for the Saturday Afternoon People Show's Legal Hour, along with my guest, Cook County Circuit Court Judge Leonard Murray, who is the supervising judge. He's going to be with us in just a few minutes. We got a great hour for you that we're going to be talking about some issues of great importance. And one of those issues we're going to talk about, I just found this out as recently as yesterday. And you're not going to believe this, but we're going to be talking about auto impounds. If you own a car and somebody uses your car and commits a crime in it and your car gets impounded, there are some things that you need to know as the owner of that car of what you have to do to make sure that you recover your car and that you recover your car without a whole lot of penalties that had nothing to do with you. So Judge Murray is going to be talking about that issue at some point in time. We're also going to talk about the city of Markham, the village of Markham. They are doing something that we are going to challenge. The citizens to abolish red light cameras and 10 by 10 to win are going to challenge this law. So get what's going on. Let me just give you, in Markham, if you are a property owner in Markham and you rent your property to someone, right? You rent your property to somebody in Okay. All right. So if you own a property, you're a landlord in the village of Markham, and you rent your property to somebody in Markham. Now they're your tenant. They own cars. They're not your cars. And so you go to Markham and you have tenants there, and your tenants rack up all kinds of parking tickets, parking violation tickets on their vehicle. Well, Markham's new mayor said that landlords are responsible for tenants' fines issued in and around their property if the tenant does not pay up. Del Bragg bought a home in Markham, an investment property, and he was not able to get an occupancy permit for his property because his tenant, or the previous tenant, racked up all kinds of parking tickets for their car. And unbeknownst to him, when he goes down to the village to get whatever the permit that he needed to get, they told him that they would not issue the license or the permit until he paid almost $6,000 in fines and fees that had nothing to do with him or his property. And I wish I had loaded the story up for you, but I'll do that again because I'm going to be talking about this, I'm sure, at length. But he racked up all of these tickets. He racked up all of these fines, or his tenant. He didn't rack them up. His tenant did it. Racked up, amassed all of these fines. And the village is now saying, with the new mayor there, is saying that they are imposing the responsibility to policing people who have vehicles parked in and around their property on the property owners. Now, you know we're going to challenge this. We're absolutely going to challenge this. And if the mayor of the village of Markham is imposing what we believe is really kind of an abuse, as well as we believe it to be unconstitutional, that if this is what he is doing, I'm not so sure that that's a person that you want to be entrusting your government with. But we're certainly going to be challenging this. We're going to talk about this a little bit later on, but we're going to get into our legal hour. And again, I want to remind you all that if you have any questions related to any legal issue, you can type your question into the chat, and I will read the question off to Judge Murray, and he will address your question and respond to it. Now, remember, the judge cannot give you any legal advice to any case of yours or someone else's. He can only address a legal question, and he'll respond to you with the legal answer and what that process is. All right. So he cannot give you legal advice. So always have to put that disclaimer out there so that we don't have any problems with compromising the judge or his position. He is the Cook County Circuit Court judge, supervising judge over the what we call it housing, safety, real estate in the city of Chicago and in some areas of Cook County. I think we're having a problem there. Your light is not good because it's got you kind of blacked out there. You just kind of see a silhouette, Judge. So if you can kind of work on that, I'm not sure if it's the location there or. But at any rate, we're going to while the judge is working that out. I'll certainly come back to him when he's ready, and we'll get right into it. But just remember that any legal question you have, type it into the chat. We'll read it off in the chat and make sure that the judge has your questions. Okay, he's back. All right, Judge Murray, there we go. Got you. How you doing?
Good, Mark. Good afternoon. How you doing?
I'm doing great. Good afternoon. Listen, I talked with you about this, so I want to spend some time with and jump on this right up front with the story that I talked to you about briefly last night, where in the village of Markham, somebody told me this yesterday, and I thought that they had it completely wrong, and I had to go Google it and look the story up and read the stories. And so, sure enough, the mayor, which is a new mayor out there in Markham, is saying that landlords, and he says because they are the lords of their property, these are his words, not mine, that landlords are responsible for tenants' fines issued in and around their properties if the tenant does not pay up. Your thoughts?
That's a novel legal theory.
Yes, it's a novel legal theory that I've spoke to a number of people, including yourself, that nobody seems to think that this is supported by any statute, or certainly is not supported by the Constitution whatsoever. That even if you're home ruled, that you can impose this kind of sanction on somebody else, on a property owner, for people who somebody else's vehicles.
Well, as you know, Mark, Illinois is what is referred to as a home rule state.
Mm-hmm.
So under the Constitution, towns, villages, cities are permitted to enact ordinances that deal with health and safety within their political subdivisions. But I don't know that authority would give them a right to impose collection of someone else's sanction against a connected party just because they happen to. Um, I guess these folks are tenants of property owners. That's a legal theory that I have never come across.
Yeah, we are certainly going to challenge it, and we're going to certainly put a lot of pressure on the villages. I understand the villages probably need revenue, um, but we all have to govern ourselves with inside a body of practices and principles according to the law and the Constitution. And so, because I have to pay my bills, doesn't mean that I can do anything that I want to do to generate the revenue for me to meet my obligations. And I think that our governments have the same responsibility to to operate and to govern as well. So this is going to be a very interesting exploit that we're going to um, look into in the very near future. I'm sure we'll be back talking about it again. I believe in conversations that I've had with other attorneys that this could potentially be a a class action. Uh, it could end up being a class action. I'm not sure how many people have been harmed by this, but we're certainly going to look into it.
Yeah, that'll be interesting. And it sounds like a situation that might be ripe for federal court, but I'm not going to comment on
Yeah.
beyond that.
Okay.
Where it might be explored.
Right. Okay. All right. All right. So you were going to talk to us today about auto impounds, getting your car impound. I think that's every person's nightmare, that their car could be impounded by the city. And of course, we all have heard, if you've never had a car imposed, most people haven't, but we certainly have heard the ghost stories in and around getting your car impounded and then having to pay a whole bunch of fees to get your car, if you end up even getting your car, to your car being destroyed or auctioned off. We've heard them all. So we're here to talk about that. You're going to give us some detailed information that we can learn about this, and so the audience uh, stay stay connected to hear about the impound process and things that you, even if you think you know, after this conversation, you're going to learn some things that we didn't even understand in that process. So I'm going to turn it over to you, Judge Murray.
Okay, well, we're going to dovetail a bit on the story you led off
Mhm.
today's session with, and that is the whole idea of home rule. Um, and again, City of Chicago has enacted, and Cook County as well, and probably political divisions outside of those two have enacted um, local ordinances to govern health and safety within its boundaries of influence and authority. Um, and in the city, um, um, there is a whole range of ordinances that deal with the issue of the city's authority to impound a vehicle. And they come up in a couple connections. First, let's deal with the idea of having simple parking tickets that go unpaid. And after a period of time, the city has the right to boot your vehicle, which means immobilize it. Uh, that's the technical term, immobilization. And if you don't respond to that immobilization with a certain period of time, they will then tow your vehicle and put it in one of the city pounds. Um, and that then, in addition to whatever the um, unpaid tickets might be, and of course, it's also important to know with a uh, city ticket related to run-of-the-mill fine of some sort, red light, um, uh, stop sign, which typically would be given by some of the ticket writers, speeding, which are the electronic tickets, um, and others. And there's a whole plethora of reasons why you can be ticketed related to vehicle operation or ownership. Um, Once that ticket reaches the stage of having been determined, if you do not pay it within 25 days, then there's an additional fine that can be levied on top of the fine for the underlying violation. So, for example, there's a requirement that vehicles owned by city residents have a city sticker that's displayed. That fine is $200. There was a period of time where the fine for not paying that fine, at least the penalty for not paying that fine, doubled. So a $200 ticket then became a $400 ticket. They've now changed that, realizing that it really was an absurd result. So now the fine for or the additional penalty for late payment for a city sticker violation is $50. So if violation is adjudicated and you don't pay within that 25 days of adjudication, then there's a $50 uh, penalty, if you will, added onto it for not paying. So many other types of violations incur a doubling, for example, um, um, speeding ticket, which is typically $100, that doubles to 200. And it's a function of what the underlying violation is that determines how much the late payment penalty is. Um, so, in that situation, as I mentioned, if you accumulate a certain number of unpaid tickets related to vehicle ownership, um, it is two tickets that are at least a year old. So, meaning those two tickets have not been paid, have deemed a violation, adjudicated a violation, and they're not paid within 2 years of the last adjudication, then you are subject to be booted or immobilized, is the legal term. And then ultimately, if it's not addressed within a certain period of time, um, then your vehicle can be towed and put in a city pound. Now, if you accumulate three unpaid tickets at any time, then you're subject to be booted or immobilized. And again, if you don't address that situation within a certain period of time, and I want to say it's 48 hours, but don't hold me to that, then your vehicle can be towed to a city pound and left there until such time as it's addressed. Now, you are required to be given notice of the impound, and it's a 15-day period of time within which, after notice is provided to you, that you can seek a hearing on the issue of the impound. Now, it's uh, um, uh, so it's important that you respond and request a hearing within a period of time. And Mark, don't hold me that to that date, that timeline. At least I know it's 15 days relative to impounds related to so-called criminal situations. I think it may be a little shorter, where it's related to run-of-the-mill parking ticket for which the boot occurs, accumulation of those. But I know with respect to this other category of violations, which we'll get to in a moment, it is 15 days. But uh, once that immobilization occurs, then you need to respond, and typically it's accompanied by this very hideous orange sticker that they put on your windshield or side glass to alert you to one, the immobilization, and also your obligation to respond to do something. Otherwise, it's subject to being your vehicle is being subject to be towed. Now, the other thing about these violations that's important to know is that um, the responsibility is not on the person who happens to be operating the vehicle at the time. It's a strict liability situation, so it's imposed on the owner of the vehicle, no matter who is operating it. So if your vehicle is cited for speeding, if you will, electronically, even if you do not are not operating the vehicle at the time of the alleged citation violation, you're responsible. So uh, I, there are a number of situations that I've had where mom and dad gave the keys to uh, their child, and then the child then passes the keys along to a friend who they happen to be with. Um, so even if that's the situation, unless um, that parent or owner of the vehicle is going to suggest that um, it was an unauthorized use, which would suggest theft, um, then you're responsible. So it's important that you know that, because the fact that you loaned it to your child, who then passed the keys along to a friend who's operating the vehicle and accumulates the infraction, um, then that's not going to be a defense, because it's a strict liability ordinance. So it's imposed. Liability is imposed on the owner of the vehicle, uh, not the person who's operating at the time. Now, the other thing that's important about that is uh, if you attempt to, and we'll get into this as well in this the second category of immobilizations uh, related to alleged criminal activity, is that if you are not the operator of the vehicle at the time of the alleged infraction, it's difficult to put on the defense because you weren't there. So if you want to attempt to defend the ticket, uh, then you need to bring with you uh, those persons who had possession of the vehicle at the time of the infraction. Otherwise, you're not able to lay any testimony about what occurred because you weren't present. So that's very important, because you can go down and protest it, but what actual information do you have to assert as a defense if you were not present at the time of this occurrence? And the other footnote I'd like to put on this, and this will also take up when we deal with the other categories of reasons why your vehicle can be immobilized and taken to a city pound, and that is notices in this area are sent to the last registration address for the vehicle. So if you happen to move um, and you do not update the registration of the vehicle with the Secretary of State, those notices are not going to get to your current address unless you may have put in a mail forwarding card to your current address, and the post office correctly acts on that. But otherwise, the notices are not going to go to your current address because the Secretary of State is not aware of it. So it's important that you maintain current registration information with the Secretary of State, because that's where notices go relative to any vehicle infraction that may occur. So,
And that registration, to clarify, it is where the vehicle is registered, and you have to make sure it's not automatically when you go to change your address for your mailing address. It is where you have to also change the address for the registration of where your vehicle was registered previously or originally.
right, and it may also be necessary for you to change the address on your driver's license. So,
Right.
information related to your vehicle certainly must be current if you want to make sure that those notices are sent to you properly. And then also you need to review what the requirements are for the listed address on your driver's license. So now let's segue over to another category of reasons why a vehicle at least with regard to uh, alleged city vehicle operations, you can be your vehicle can be impounded, and that relates to a police stop. So let's say um, police pull you over for some reason. Um, could be any number of things: tail light out, headlight out, missing rear plate. There could be any number of reasons why you could be pulled over by a member of the Chicago Police Department. And incident to that encounter, um, typically they're going to ask for you to display and present a driver's license. Um, if you uh, don't have a license, then it can be suggested that you're driving without a license, which would then give the city the right to impound a vehicle because you're not displaying the fact that you have the right to operate a vehicle at that moment. Um, Now, that's one of the more simple and maybe more innocent situations. But let's say, in addition to uh, the request and seeking um, information related to your right to operate a vehicle, let's say they search your vehicle and they come up with some contraband of some sort, at least what's believed to be contraband of some sort, or a weapon. Um, then and if that there is a charge for possession of illegal substance and or a weapon that's not authorized or at least not properly secured in terms of your travel, then that is also a basis for the impounding of your vehicle. Now, in that situation, there is a notice required to be given to, again, the registered owner. And if that happens not to be you, again, that notice, that 15-day right to seek a hearing on whether or not the vehicle um, could have been impounded, is going to be sent to the registration address of the vehicle, the plate registration address. So again, in order to protect your rights, it's important for you to um, have uh, current information with the Secretary of State regarding registration of the vehicle. Because again, it's a strict liability situation. So if you have uh, loaned that vehicle to someone who then gets pulled over unbeknownst to you, um, then in order for you to assert whatever rights you think you may have in that situation, um, they're going to send that notice to the registration address based on the plate. And if that information is not current, then you may not become aware of what's occurred. Now, they also send notice to lien holders in that situation. And I've seen situations where if it's a recent transfer of title, then they may send notice to the last holder ownership information relative to ownership, holding of title, and anyone else that they may find. But again, it goes to address, and in that situation, they're doing it based on the VIN number. Um, Again, information that the Secretary of State has based on VIN number, and of course, that's going to be based on whatever address information has been provided to the Secretary of State. The city of Chicago, as such, does not maintain registration information relative to the ownership of vehicles. So I, I hear that sometimes. Uh, why didn't the city know my current address? Well, because they share information. At least the Secretary of State allows the city to access its database, but it's the Secretary of State's database, it's not the city's database. So they're going to rely on whatever it is shown in that database of information. So um, if you're someone who from time to time might be kind enough to loan your vehicle to someone, you're going to want to make sure that registration information is current. Otherwise, you risk the possibility of not becoming aware of what's happening uh, relative to the operation of your vehicle when you loan it. And you might think that, well, the person who I loaned it to certainly is going to tell me what occurred. Don't be so sure about that. They may not alert you to what's occurred. They may come up with a story either based on embarrassment or believing that they can kind of work this out without your involvement. So you may not be told about what occurred. I recall a case a couple of years ago where a mom had loaned the car to her daughter. Daughter then passes the keys over to the boyfriend. Um, uh, the story she got about what happened to the vehicle was nowhere near the truth. Um, and again, because she was not in the vehicle uh, at the time of the police stop, there was nothing that she could say relative to whether or not what occurred, the basis for the stop was legitimate or not, or lawful or not, because she wasn't present. So, but but in that situation, the registration information was current, so therefore she did get notice of it um, uh, to attempt to enforce her rights. But that's not always the case. So it's very important that um, you make sure that the registration information is current to protect your interest.
The
So
other, the other, one of the other things I wanted to mention, because on the first part of this discussion, we were talking about the things that people need. One of the things that they will always need, Bob Fioretti noted, they should make sure they have a copy of the police report.
yes, which means making a request for it, going to police headquarters and making that request to see what the narrative is relative to the stop. Um, but again, if you were not operating the vehicle at the time of the stop, there's nothing you can offer relative to whether or not it was appropriate or not because you weren't present. So unless you have, in the context of a hearing, contested hearing, unless you got uh, those folks who were actually on scene at the time of the stop, then it's going to be very difficult to assert a defense because you have no comeback to what the testimony might be from the police officers who were involved in the stop. And of course, police reports in the civil courts, criminal courts are hearsay; they can't be used. Um, but at the administrative level, um, the rules are more relaxed. So many times they will allow the introduction of the police report to the extent it bolsters the city's case for justifying, um, you know, both the stop and the impound.
I would think that the city would want to see the police report because it gives them context coming from a peace officer or certainly someone who writes the incident up as opposed to the two parties or parties.
Well, what happens though sometimes is that they don't send to those administrative hearings. They don't send both officers. Um, there may be a writer of report, if you will, but they may not send that person. They may send his partner, his or her partner, to the hearing. Uh, so uh, the report is there, but the person who wrote it and their basis of thought process in terms of what they put on the paper, you can't explore because they're not there.
Right.
Right. So just continuing on with this. Um, let's assume here that the basis for the stop was missing plate, which would be a legitimate basis. As a result of that, they explore what's inside the vehicle and they recover contraband or a weapon that then justifies a criminal charge. So That charge then allows the city to immobilize the vehicle and tow it to one of their pounds because there is an alleged criminal violation, at least ordinance violation, under city code for having a weapon in a vehicle. Now, this is very critical and something very important that everyone understands. So, if the weapons situation results in a criminal charge, that will be prosecuted by the Cook County State's Attorney, assuming this takes place in the city of Chicago. At the same time, you have a civil case that will be prosecuted by the city of Chicago before one of its administrative hearing officers related to uh, a alleged criminal violation uh, involving a vehicle in the city, being operated in the city, which is civil in nature. So let's extend this scenario further. So let's say that the and they're on two different tracks. So in the progress of each case, if you will, may not be the same. I would suspect that the administrative hearing process will likely proceed quicker than the criminal court process, just because that's just the nature of those proceedings. Um, so the city may well want to push along the administrative hearing process related to justifying the immobilization and impounding of the vehicle um, because that's in their best interest. They don't want to wait to see what happens with the criminal matter because there's some outcomes there that may not be favorable to the city. Um, so it would be important then for a person in that position to try to push along the administrative hearing process to coincide with the outcome in the criminal case. So, for example, the fine for uh, discovery of a weapon in a vehicle is $2,000. That's a fine,
The money fine.
the money fine under
Right.
city ordinance. Also, there will be a tow charge of I think it's $150, maybe thereabouts. And then there's also daily storage of $25, I think, for the first 20 days. And then after that, I think it decreases to 20. But in any event, so day one of that vehicle being in the pound, the cost is already more than $2,000. Now, you are permitted to retrieve it if you like, um, to pay the fine, uh, which would be the $2,000 plus the tow charge and the daily fine. I'm sorry, daily storage charge because it incurs a 1 day storage charge as soon as it hits the yard, even if you recover it within a few hours of the occurrence. But day one, in order to retrieve that vehicle prior to hearing of some sort before the administrative hearing tribunal, you're already looking at more than $2,000. In the
Even the person
meantime,
who owns the car and they had nothing to do with it, they couldn't contest that.
they can contest it, but again, if they were not present at the time of the occurrence, then I don't know what testimony they could offer about uh, the impounding of the vehicle unless they're going to claim that it was stolen and that the person in possession of it didn't have it with their consent.
What if they turned in the information of the person who was driving the car? If they
What
could prove
well, that would be known because there would be an arrest,
right.
right? So that would be known who was operating the vehicle at the time of the stop. That would be known because it would result in an arrest. Uh, and as you suggested, you can obtain a police report. Um, and at the time of the administrative hearing, they will turn over to you whatever documentary evidence that they plan to use to support the stop and the impound. So you'll know who it is if you read the police report.
Right.
But so then let's assume this is a situation where in the criminal court context, which again is not prosecuted by the city. City witnesses are used, but it is not a city prosecution. It is a state law prosecution, alleged violation under state law. Um, if the state's attorney decides to decline prosecution, um, then of course that's a favorable outcome to the defendant in that situation. We're talking about a UUW, unlawful use of weapon. Uh, that does not necessarily uh, win you the case, the civil matter in the administrative hearing process. It's important to know that. I've
Hmm.
had any number of folks who in that context, who come in and say, Judge, they threw the case out. I said, well, sir, that's good for you for avoiding the criminal prosecution, but it does not solve the question of whether or not the impound in violation of the city ordinance um, uh, is favorable to you because it's a civil process, not criminal. And
Unless it now would that be written? Let's say you went on the administrative level on the civil side of it, and there was an adjudication of it, and you were, um, or what's my question? It was disposed of, but the person who is the alleged offender, um, that it was determined that that person was the person who was driving the vehicle or certainly in possession of the vehicle. If, as an owner, if you're able to provide that information and substantiate that, is there any relief at the administrative level?
not if not if they're in that possession with your consent. But again, it's not going to be a mystery in terms of who was in possession of the vehicle at the time of the police stop, because there's going to be an exchange that happens there.
Hmm.
You know, the vehicle stopped. They've got an operator of the vehicle behind the wheel. Uh, um, they they will ask for a driver's license uh, to be shown, um, and if they don't have a license, then they're going to ask who you are. Um, so you'll disclose, at least give a name. But in any event, there will be a report that's generated because ultimately there's a charge that's going to be levied against whoever is operating the vehicle at that point.
Right. And you
Um,
got to be, as property owners or car owners or auto owners, you have to be careful who you are allowing to drive your car. And you got to make sure that that person has insurance, or not necessarily insurance, but make sure that that person has a valid driver's license. Now, I'm not
exactly.
sure whether or not people can find out, whether that person has a, a soiled driving record or not when you're lending
Yeah,
somebody your car.
that's more difficult, especially in the heat of the moment, so to speak, when someone's asking, "Can I borrow your car?" I'm sure they're going to suggest, and you certainly could ask, "Let me see your license," maybe even snap a picture of it. But I don't know at that instance if you have the ability to somehow discover whether or not there's any brick on the license, if you will. Because that's not. I don't know of a phone number that you can call and voluntarily be given that information.
Right.
Um, yeah, but
Yeah, I would think that would be more difficult because of privacy protections.
right, and the Secretary of State wouldn't know who it is that's calling, trying to determine the status of someone's license. Um, but so let's continue to explore this scenario.
Mhm.
So if the operator vehicle, who then is a defendant in the criminal case, um, believes that the stop was not constitutional, not valid, and has a representative, a lawyer, who, after reviewing the facts, also believes that the stop was bad. Um, they can file a motion to quash, arrest, and suppress evidence, suggesting that there was no lawful basis for the vehicle to have been stopped, and if it had not been stopped, then none of the rest of this would have occurred. Um, so that's helpful in the criminal context. Um, and it may be helpful in the civil context relative to administrative hearing. And that's why it's important that if you can, you delay that process to coincide with the outcome in the criminal case, if you can. But um, if a motion is put on and a judge believes that the stop was bad, that there was in fact a constitutional violation, then of course, typically the state, uh, there'll be an order granting suppression of the evidence and quashing the arrest, and that typically uh, means that the state has no ability to move forward on the case, and they will typically dismiss it at that point. So the issue then becomes, what is the impact on the administrative process that could result in the fine that we talked about, the $2,000 for the alleged ordinance violation, and then the tow and the storage. And by the time all this occurs, that daily storage could amount to quite a bit of money. And one of the things that I have done in that scenario is that I accelerate the time for the city to, one, answer the petition for review by requiring that they file the record in no more than 30 days. And then we accelerate the hearing because if in fact uh, uh, the the petitioner on administrative review prevails, then they've been without their vehicle for a number of months, possibly at that time.
Mhm.
You know, I've seen situations where uh, it could take up to 4 to 6 months before you actually get to hearing on the merits of the administrative review process, just because of the timeline to get things done. Now, when I first came into the division back in 2016, the city was asking for 120 days to file the administrative record. So what that meant is, in the situation of an impound, uh, by the time you get around to the court case, that vehicle probably has been in the pound for 6 months.
And the owner of the vehicle is responsible for whatever storage costs related to the impound.
Exactly. Should they not be successful, then you're right. You're accumulating uh, probably as much as I think my memory's right. It does reduce to $20. I think it's after a certain period of time, and I want to say that's 20 days or 25 days. But $20 a day for 30 days is $6,000. So every month, uh, after the first month, you're accumulating a potential $6,000 storage fee on your vehicle before you get to the merits. So I thought that was patently unfair, and I shortened the timelines for this because, uh, before,
$600.
right?
$600.
I'm sorry. No, yes,
20,
I'm
yeah,
sorry.
$20 a
Sorry,
day at 30 days is $600. Right. Right.
right.
Mhm.
Sorry, my
Yeah.
math is wrong there. Uh, so yeah, $600 a month. So um,
It's a lot of
after
money.
yes,
Yeah.
so if
And
it
impounds, they tack on all these other fees or whatever they may uh, tack on for
well, you got
penalties and that sort
you
of thing.
got the storage fee
Right.
and the tow. That's automatic over and above whatever the underlying fine is.
Right.
So, um, but even if you're successful with the criminal case, and if you're successful in terms of a motion that attacks what occurred on a constitutional basis. Uh, you could also be successful at trial, but that wouldn't necessarily mean that the stop was unconstitutional. It would just mean that on the merits of the charge, the state was not able to sustain its burden. Um, so the best outcome for the owner of the vehicle in that situation is a successful motion to quash arrest evidence, because then it raises the issue of whether or not, since the stop is deemed unconstitutional, should the city uh, be rewarded for unconstitutional conduct? And I'll just say that's a question. Leave it there at the moment. Um, but that issue is there. If in fact the stop is deemed and what occurred deemed unconstitutional, then it may well shift the burden in terms of justifying what occurred to the city versus the owner of the vehicle. But the importance there is that to understand that transaction, that occurrence is proceeding along two tracks. And winning on the criminal track in terms of the case, either the state declining prosecution or winning a trial, does not necessarily mean that you will win at the administrative level, um, because unless there's a test made of whether or not the stop was appropriate, you don't get to the constitutional issue of whether or not the police department acted in a lawful manner, unless there's a challenge made there. So it's very important to understand that. And also, you cannot wait till your criminal case is over to then go in and protest um, the impounding of the vehicle by the city on the civil track. It'll be too late. There are timelines in place, and if you don't act to object to what's occurred before the administrative tribunal, then you may have waived your right to attack it. Even if you ultimately win the criminal case, if you have not acted to protect your position in the civil side of things, it may be too late. So it's very
Well,
important to.
there's two separate sides. So you have the civil side, and then you have the criminal side. The criminal side is the person who actually was using the vehicle that committed the alleged offense, and the civil side of it is the person who owns the vehicle. Is that person allowed to go and to contest or to defend their position immediately, or do they have to wait until that case has been fully adjudicated or prosecuted?
Now they've got to go in and request a hearing, at least essentially an objection to what's occurred to preserve their rights.
Right.
And then, as I've suggested, if they are not present at the time of the stop, then there's really no testimony that they can offer because they weren't there. They don't know what occurred. They don't know why the stop was made. They don't know what led to the search of the vehicle, or even um, whether or not the operator presented a license or not. Because you can also, we use the example of a weapon being discovered, but you can also, the vehicle can also be impounded if a person is driving on a suspended or revoked license. That's also a violation under city
Mm-hmm.
ordinance. Uh, the fine is less, I believe. I think that's $1,000 fine, but it still can result in the vehicle being impounded. So, but in order to um, keep open the question of the possibility of the civil or city ordinance violation remaining in play, you got to go in and request the hearing and be clear and adamant about your need for a continuance in order to allow information from the criminal case to be obtained, and maybe even the outcome there to be decided. Because again, if the operated vehicle who is a defendant in a criminal case is successful in somehow on a motion to quash, arrest, suppress evidence, that may be helpful to you before the administrative tribunal in terms of attacking what occurred from a constitutional standpoint. Um, and then, of course, hopefully, that person will be helpful to you in the administrative process by lending their voice to as a witness to what occurred as well. Because the owner of the vehicle who's loaned it out or somehow come into the possession of someone that they may not have known at the time, but essentially um, allowed it to occur, um, won't have any direct information about the transaction themselves because they weren't present. So
Yeah, it raises some other questions, about lending people your car,
yes,
because you're still ultimately responsible. So, you need to make sure that people have a valid driver's license. If you're going to lend somebody your car, ask them to present to you a valid driver's license, so you will know that the person that you're giving your car, at least that person is licensed and legally able or permitted to operate a vehicle.
right. And the other reason, uh, uh, in terms of loaning out your vehicle, is even if there's no criminal allegation present in all of this. Um, let's say you loan your vehicle to someone who unfortunately is involved in an accident, uh, then you can be named as and it results in litigation for personal injury or property damage. You can be named as a defendant in that context because there could be a question as to whether or not um, the person operating the vehicle was your agent at the time of this accident, and therefore you could be liable for damages personally because they were undertaken and engaged in some activity for your benefit.
Mhm.
So that's also a reason to be very careful about who you give your car to, and even if ultimately, and the burden would be on the plaintiff in that situation to prove agency and so forth. But still, you're involved in litigation, and being involved in litigation does cost money.
Yeah. Well, we got about a minute left, so but this is some very powerful information. We're going to have to continue this in next week. But if you want to give us some closing remarks on this, and then I think we probably need to carry this over for next week because this is very, very good information.
Sure. Well, the first thing is that in a situation where your vehicle has been impounded in the context of a criminal situation, it's very important that you do not sit on your rights relative to the administrative process. You have to request a hearing. And if my memory's right on this, I think it's 15 days after notice of that process. And the notice that they give you is one um, that's not the easiest read. They put all this information on one side of an 8.5 by 11 sheet of paper. It is not all that distinct, but it's very important that you try to gain some knowledge about what's there, so you can act on it to protect your rights. Um, and you also cannot wait on what happened, of what's going on with the companion criminal case, because even if that's successful in its outcome, it may be too late to then go back and try to uh, assert your rights uh, in the civil side of things, which is excuse me, which is the administrative process there. And also, please know this: the fact that the state declines prosecution and or the defendant wins at trial, that is not necessarily a defense to the administrative hearing process because it does not raise the issue of the constitutionality of the police stop. So it's very important to understand the rights and differentiation between the civil and the criminal, because not knowing can be very detrimental to your position.
All right, we're going to have to wrap it up and leave it there. We'll carry this on next week. Thank you, everybody. Thank you, Judge Murray, for being here this week. We're going to be carrying this conversation over next week. We'll bring you some more topics, and we'll take all of your questions. Make sure you all tune in to the Monday night edition of The People Show on intellectualradio.com, Instagram, Facebook, YouTube, and X, formerly known as Twitter. Next week, I start the deep dive into giving you the specific facts on the Biden-Harris accomplishments, so that you will can be informed on what a great job this administration has done and the things they're doing, certainly going into this election. It's an extraordinarily important election, probably more critical than any of the other elections that we've been involved in. All right, that's coming up on the Monday night edition of The People Show. Judge Murray, thank you very much. Have a great weekend.
All right, you too, Mark. Thanks for letting me be part of this.
I appreciate it. Thank you so much. All right, folks, so that's going to do it for this week's edition, or this Saturday edition of The People Show. Going to bring more content to you coming up next week, as well as we will probably have some special shows. Don't forget about 10 by 10 to win. We are organizing the largest Black independent voting block here in the city of Chicago, the county of Cook, and the state of Illinois. Go to the website 10by10towin.org, and you could also get into the text alert by texting 10x10 to the number 855-909-1385. That's 10x10 to the number 909 or 855-909-1385. All right, have a great evening. We'll talk to you later. Great weekend.